Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
May I please, Your Lordship?
Yes.
Lordship, this is a contempt petition on Power Distribution Corporation.
Yes.
Lordships, by an order of 14 in a writ filed by the corporation, Lordships had set down certain timelines.
Where is the order? Where is the order?
Lordship will find the order at page 31.
21.
The operative portion is at 31.
31 operative portion.
At 34 bottom. Rather 35 over the page, Lordship. Para 12.
The petitioner complains of the breach of an order dated December 14, 2022 by the respondents herein. Full stop. The petitioner will serve the respondents and inform them that the matter will appear a week hence. Yes.
Walk through counsel.
Yes.
The company walk through counsel. I are represented.
Yes. Serve it on them. Contempt petition can't be served on counsel. It has to be directly on the alleged contempt, not.
I'm obliged.
From the main list, item number 1.
May it please, Your Lordship? Your Lordship, I am appearing for the petitioner in this matter, Your Lordship.
Yes.
Your Lordship, we have received the pleadings, my Lord. The affidavits from the respondents, we have received them. We need some time to examine them and file our rejoinder application affidavits, my Lord.
Very well. You filed your affidavit. Yes. The state has filed its affidavit. Full stop. The petitioner seeks some time to use a rejoinder. Full stop. Let the matter appear a fortnight hence. Paragraph. In the meantime, the state should do all within its power to ensure that the matters complained of are appropriately addressed.
Item number 2.
Okay.
May it please, Your Lordship.
Yes, sir.
Your Lordship, we are against the state is before Your Lordship against the order of judgment and order of learned single judgment, Lord.
Yes.
We amended the employee service rules for aided college, whereby we barred them from participating in the election, Lord.
Participating in
the election and holding the offices in political parties. That amendment was challenged by petitioners by making a prayer that the amendment should be struck off and direction be issued to restore the amendment, my Lord. If I can place the amendment, my Lord, straight away, what learned single judge has held in the judgment, 2 findings have been returned. One, that it is not an office of profit. Teachers who are receiving grant in aid, those teachers who are working in the colleges and schools who are receiving grant in aid are not covered by the office of profit. Secondly, the amendment is not reasonable. These are the 2 bases of striking down my amendment, my Lord. First, my submission is, so far as office of profit is concerned, my Lord, that issue can be examined and factual findings can be returned. But so far as the reasonability
has already been decided conclusively by the
number of judgments, my Lord, I have relied upon that. But first submission, which my first and foremost submission, my Lord, is that it is the policy of the government and it is part of the rules that
generally,
yes,
government servants
are not allowed to
entitled
yes,
to
sir.
Participate.
Yes, sir.
They have to resign and do.
Yes,
but that applies only to government servants and even PSUs
Yes, Lord.
Even PSUs, anyone holding any post, office of profit.
Yes, Your Lordship. Now, the issue which failed for consideration of learned single judge is that whether, because we are giving grant, and this is one of the condition of the grant, if the schools and colleges are receiving grant, and in order to receive the grant, this is one of the condition, my lord, and this condition is that you will not contest in the election unless you resign. That is the amendment which we brought, keeping in mind the fact that the teachers of the aided colleges are going in election mode and they are not paying attention to the teaching duties. So this is the...
Now, the moment you bring about an amendment,
Yes, Lordship.
then you accept that without the amendment, they are entitled to
Yes,
contest.
sir. They were allowed to participate in the election process subject to certain conditions. Those conditions have been deleted and omitted by the amendment, my lord.
No. So, therefore, once you accept that without a specific law, they can contest, it implies that you accept that it is not an office of profit.
Yes, Lordship, to that extent I have to...
implies that you accept that it is not an office of profit.
Your Lordship is right, that to that extent, my lord, I will labor hard, because if I have taken a view earlier, which may not be in consonance with law, my lord, I am at liberty to urge your lord, before your lordship, that this is the correct view which your lordship should take. But my first and foremost submission is that it's a policy decision which we have taken, and this is one of the condition of the grant, unless it is only
A policy decision, unless it's, ex facie bad or
Yes.
bad to the meanest mind, should not be interfered with. But this is a restriction on a democratic right of a citizen.
Yes, sir. Now, so far as this democratic, the restriction is there on the government servant, my lord. Restriction is there on the teacher.
Therefore, why do you need an amendment?
So, because, my lord,
Why do you need an amendment? Even without the amendment, you can contend
Yes.
that this is an office of profit and you are not entitled to. Why are you introducing the amendment?
now there are two aspects of the matter, my lord. So far as office of profit is concerned, my lord, if they contest election, they succeed, their election can be set aside if on the ground that they are holding the office of profit. That is an independent issue. My issue is that as a policy, my lord, when I have come out with the policy imposing restriction on the teachers who are teaching in the grant in aid college, they are receiving the grant, and for betterment of education, betterment of teaching, whether I can introduce this rule in my...
It has no nexus with teaching. It has no nexus. Your providing grant in aid
Yes, Lordship.
is to ensure that your obligation as a state
Yes.
to empower citizens
Yes, Lordship.
is fulfilled.
Yes.
That is to broad base the education structure.
Yes.
That's why apart from institutions that you own,
Yes, sir.
you spread it out so that others can participate and you support them so
Yes.
that, because they are enlightening, educating, empowering your
Yes, sir.
citizens.
Taking clue from what
Now, that is the object of the exercise.
Yes.
The object of the exercise is not to curb their rights.
No, Your Lordship, the exercise has two dimensions, my lord. One, empowering the institutions and the citizen, which we can't provide on our own. Therefore, we are taking help of the private educational institution. At the same time, the object is also to see that the quality of education is imparted.
So there is nothing to do with quality of education.
If they are holding the political post, my lord, they are doing political activities, they are participating in election. Ultimately, it will definitely, in my humble submission, affect the standard of teaching, my lord. Because empowering and as a condition of grant,
Does it affect any politician's, affinity to amass money just because he's a politician?
no, Your Lordship,
On the sidelines, he does that.
Your Lordship, the point is that if the teacher is doing the politicking all the time, my lord, because we have witnessed that they are doing all these things. So therefore, this policy has to be tested on anvil of whether it is reasonable, unreasonable, or it could not be a condition of grant, my lord. The management has not complained. Management is accepting it. Teacher has come and saying that this policy is taking away my fundamental right, Article 19(1)(a) to part the form association and part
Because
of
Article 19 has inbuilt restrictions.
inbuilt restriction, my lord.
And those are exhaustive.
Yeah, those are exhaustive.
Those are exhaustive. You can't go beyond Article 19.
Therefore, I was urging your lordship, this requires some consideration, and I will place the authorities on this issue, because this is one aspect of the matter, and second is office of profit.
Because what you're doing is, without meaning any disrespect, if it is a government, if it's a college teacher, he or she has some educational background, he or she can contribute in a more enlightened way than your mass politician of today. If you remember, there were debates in the Constituent Assembly, and this is one thing that is a pet subject with me. There were debates in the Constituent Assembly, and initially certain qualifications were prescribed for persons to hold posts of legislators both in the assemblies and in the parliament.
Yes.
Then came a very impassioned plea by some that why should those who have not had the opportunity of education in a democracy be left out just because they did not have that opportunity. Which is why the qualifications were dropped in the Constituent Assembly debates. And it was hoped that in due course, those qualifications will be added as the opportunities are made available to citizens.
Yes.
Yet, there is nothing which the parliament has done, because politicians control the parliament, nothing which the politicians have done for election laws, for nothing under Article 329 or 324, what is it?
324.
324. No law has been brought about by the parliament. We have nota, which is a result of Supreme Court judgment. We have criminals, which is a result of Supreme Court judgment. Nothing on disclosure, nothing. Because it suits the politician that way.
All these reforms have come by virtue of the judgments of the Honorable Supreme Court only. Continuous.
So if you have an educated, previously look at your politicians, look at the leading politicians. They came from
Very educated.
lawyers, teachers. But today the respectable person does not want to enter politics, because that the moment you identify yourself as a politician, there's a bad baggage that you're carrying.
Yes, sir. Your Lordship is right, but we are not taking away the right of the teachers to contest election like government teachers, my lord.
You're taking away his livelihood.
Your Lordship, because the choice we have to keep in mind, it's like balancing act, my lord. We have to keep in mind the teaching atmosphere or the betterment of, and at the same time, we have to protect their rights. Because your Lordship knows that this politics is full-time kind of thing nowadays. And what is happening, because what we noticed,
And what is the difference between a person who indulges in politics, goes everywhere campaigning, does all party work, only the standing for election is the prohibition. There is no prohibition in any other work. So the excuse that you are proffering is baseless.
we are saying that you can't hold any party office also, you can't be affiliated to any political party also. My lord, so that is the amendment which we have brought. So
Even affiliated to political party, if I am a member of a political party, that is wrong.
your Lordship, if see the earlier rules which I placed, my lord, kindly see the rules on this, that what the exact rules, my lord.
What do you mean by affiliated? Does affiliated mean membership?
No, your Lordship, affiliated can be without membership also.
Then it's a rather vague word.
Yes, your Lordship, you said,
I am not affiliated to anything. You say I am affiliated.
yes, Lord.
I am not a member of any political party. You say I am affiliated.
Affiliation can be by conviction also by.
Today we have a judgment saying past party membership or party work does not prevent even a judge from holding a constitutional post.
Yes, Lord.
So therefore we have to test your law on that anvil.
Yes, Lordship. Please do that, Your Lordship. At least something good will emerge from this exercise, my Lord.
The appeal raises an interesting question as to whether teachers in government-aided schools, government-aided colleges hold offices of profit to be disentitled to contest an election or, in any event, such teachers may be subjected to a law that prohibits them from, in effect, indulging in any political activity. Full stop. Paragraph, the state is in appeal against an amendment to the rules pertaining to teachers in government-aided colleges in the state being struck down. Full stop. Paragraph, since the state seeks some time, let the matter appear 3 weeks hence.
Teacher.
Item number 3.
Yes.
Please, my lord, this is a PI pertaining to the overall conditions of jail in the state, my lord. Well, we have filed numerous reports pertaining to various correctional homes within the state. My lord, in the last occasion, my lord, the state has been directed.
I think we are doing well.
My lord.
We are doing well. There is no big grievance. I have personally visited
My lord.
Several of these places, and there does not appear to be either too much overcrowding. Of course, we are getting a new facility at Nongstoin. There is a proposal for, where is the new Shillong jail coming up, Mr. Khan?
Lordship is coming up in New Shillong only.
We had requested you to look into it.
We had expressed
New Shillong may not be the ideal place.
Absolutely, Lordship.
Because tomorrow when it,
There's an expansion
becomes a
of it.
commercial area, then that kind of land in the middle of it, you could do it on the other side of town.
Lordship, that is under consideration. We have expressed the concern of this court to the concerned department.
Because they are best kept apart.
Absolutely. When there is a growth, Lordship is very correct.
Exactly. And
We have the same situation here in the Shillong jail.
Yes.
But Lordship, the small submission on the Shillong jail, we had the extension pending consideration of the main central jail. The premise for mentally ill 100% has been completed, Lordship. At least.
Is that a vertical extension?
No, Lordship, there were 3 quarters next to the main jail, which were under construction, except for the high security wall. There is premises for the UTPs, dining room, kitchen, premises for the convict, all are 100% completed.
Justice Dingdo has been there
Lordship.
recently.
Lordship, so except for the high security wall, the instruction that we have received, there is almost, so that can easily accommodate another 100. Time being till we don't put the central jail in place. So the decongestion, that was a concern of this court and the Leonard amicus curiae was expressing, that has been taken care of, Your Lordship.
Very well.
And
The state says that the major problem of congestion at the jail, at the Shillong jail, is it called the Shillong jail or the central jail?
The Shillong jail, Your Lordship.
As the Shillong jail has been taken care of and new buildings have come up. Even though it is proposed to shift the entirety of the Shillong jail to new premises. Full stop. the state has proposed to earmark a much larger area for the Shillong jail complex. Full stop. However, the proposal is that the new jail come up, wherever I'm saying jail, make it correctional home. That the new correctional home will come up in New Shillong, where government departments are proposed to be moved and a commercial hub is under construction around the area where the new assembly has been built. Full stop. The state government is requested to look into the feasibility of having a correctional home in or around a commercial hub, and the state may consider locating the correctional home at the other end of Shillong, where sufficient land may be available. Full stop. However, comma, it is for the state government to take a decision in such regard. Paragraph, in respect of the general state of the correctional homes in the state, comma, you are appointed amicus curiae.
But in fact, Mr.
You are the petitioner.
My lord, yes.
The petitioner does not have any major grievance, full stop, after the normalization of life post the COVID lockdowns, comma, regular visits have been conducted by judicial officers in the districts, comma, state legal services authority representatives,
Including the state councils, Your Lordship, we also visited. The state councils also, as per direction, we have visited, Your Lordship, the jail, as per
And-
direction.
counsel appearing for state and high court judges. Full stop. Paragraph, there is a new correctional home coming up at Nongstoin. Full stop. The lack of funds has delayed the project already. And the state should make every effort to ensure that the work is completed as expeditiously as possible. Full stop. Is this the matter which has to be kept pending pursuant to Supreme Court orders, or
No, no, Lordship.
this is not.
That is custodial.
That's custodial. In the light of the present state of the correctional homes in the state, comma, PIL number 8 of 2019 is closed with a request to the state to ensure that quality of food, hygiene and discipline at the correctional homes do not suffer, are maintained as per the expected standards. Full stop. Yes. We are closing this.
Just one thing, my lord. If there's any lapses on the part of the state and the liberty may be granted, my lord.
It's always there.
My lord.
You always have it even tomorrow.
My lord. Duly advised.
Yes.
All right.
Item number 4.
We start again.
My lord, the two issues, out of two issues, jurisdiction matter, both of us already addressed that issue. Only the Your Lordship permits me to address the merits of the case.
No, we'll do
We
the,
decide together.
we will do the jurisdiction. Merits you might win. We'll do the jurisdiction and then we'll do the merits immediately after that. Because we want to, if the jurisdiction, you succeed, we don't need to go to the merits.
That is.
That's why we want the jurisdiction. That's why we had indicated, whether today or tomorrow or whatever, take 2 days or 3 days together. All of you decide.
Yes.
And 2 or 3 continuous days if necessary. It may not be, third day may not be necessary. Take 2 continuous days, finish off and give us 2 days. We don't need any more than 2 days. You can start it today.
I can start Your Lordship in the AG also.
When?
Your Lordship may have it next week, my Lord, because.
So we'll start it on a Tuesday.
Yes, Lordship.
Tuesday, Wednesday, Thursday we keep spared.
Yes.
Tuesday, Wednesday you finish.
Yes, Lordship.
Thursday is spared, so that by the following Monday or Tuesday, we deliver the rubbish that we have to.
But what that means, we will start on Tuesday.
On Tuesday?
Tuesday.
30. In fact, 16, I have one important matter before, and it's single bench. My lord. If Your Lordship accommodates me.
Then let us start on Monday.
Monday, my lord.
Monday?
Let us start on Monday so that, you know, you'll have enough time to go and do your
Yes,
single bench matter on Tuesday.
my lordship.
Last matter on Monday.
Yes.
Right.
Much appreciated.
Item number 5.
Back to the Lordship.
Yes.
Well, this is a case where the appellant, my lord, was convicted along with another, my lord. Apparently as a transporter, although charged was not framed and
Convicted under what provision?
as a transporter, because he was riding the scooter, the appellant, and the Alice contraband was found on the, in a bag on the person of the pillion rider. To my knowledge, my lord, there is no appeal yet from the pillion rider, so the appellant is here. My lord, on the last occasion, my lord, your lordship had asked me to, how do you get over section 35, my lord, of NDPS Act? Because I didn't adduce any defense evidence, my lord. For that, my lord, first of all, I would like to take,
If you're the driver,
my lord,
then, and possession is found, the two of you are traveling together.
Yes.
It's joint possession.
my lord, it was held, but then, my lord, no question is put to me, and apart from that, my lord, link has to be established by the prosecution, whether I had abetted or aided or in
Let's see
any.
the provisions of the Act.
Yes.
Before we go into the facts.
Yes, my lord. My lord, section 35,
There is also presumption.
54. My lord, I'll come to that again also. I'm reading, my lord. Presumption of culpable mental state.
Where are you? Which,
My lord, 35, section 35, my lord, this Bayer Act, my lord, the narcotic drugs. Have you, lordship?
Yes.
Now, my lord, for my purpose, I'll read out, my lord, once again. 35(1). In any prosecution for an offence under this Act which requires a culpable mental state of the accused, the court shall presume the existence of such mental state, but it shall be a defence for the accused to prove the fact that he had no such mental state with respect to the act charged as an offence in that prosecution. My lord, here, my lord, apparently, my lord, record shows that there was no defense evidence adduced by the appellant. Now, number 2, madam. For the purpose of this section, a fact is said to be proved only when the court believes it to exist beyond a reasonable doubt.
That's a yardstick.
And not merely when it's a problem. No, because we are also stating that Caesar is not proved. Caesar itself is not proved. There was no inventory made. It was not taken to the magistrate.
This section is of no assistance to you. For that, this section is of no assistance to you. This explanation and subsection 2 are in aid of the substantive portion of subsection 1.
Yes, ma'am.
And subsection 1 gives you an opportunity to prove as a matter of fact that you did not possess the culpable mental state.
Yes, ma'am.
So it's confined only to that.
Madam. But I'll just read out.
You cannot take this and use it in respect of any prosecution matter.
Madam, in this respect, madam, there are 3 circumstances that may be, madam, in 35, madam, by which he can find his defense, madam, the accused. Madam, I'll read out, madam, please, I have brought those decisions, madam. Para 22 of this decision, madam, Mansouri's decision, Abdul Rashid Ibrahim Mansouri. This is 2002.
Give us the book.
Madam,
Give us the photocopies.
Yes, madam. Number. It will be my serial number 1 of the advanced matter. Straight away, I would like to take your lordship to para 22 thereof, man.
Paragraph?
Para 22.
Just 1 second.
Fine. We'll give you a list also. 2002 SCC. 513. May I read out, madam? Yes.
Next.
Yes, paragraph 21.
Para 21 and para 22, madam, both, madam. I'll read out, madam. No doubt when the appellant admitted that the narcotic drug was recovered from the gunny bags stacked in the auto rickshaw, the burden of proof is on him to prove that he had no knowledge about the fact that those gunny bags contained such a substance. The standard of such proof is an appraisal of the entire, is delineated in subsection 2 as beyond a reasonable doubt. If the court on an appraisal of the entire evidence does not entertain doubt of a reasonable degree that he had real knowledge of the nature of the substance concealed in the gunny bags, then the appellant is not entitled to acquittal. However, if the court entertains strong doubt regarding the accused's awareness about the nature of the substance in the gunny bags, it would be a miscarriage of criminal justice to convict him if of the offence, keeping such strong doubt undispelled. Even so, it is for the accused to dispel any doubt in that regard. The para 22. The burden of proof cast on the accused under section 35 can be discharged through different modes. One is that he can rely on the materials available in the prosecution evidence. Next is, in addition to that, he can elicit answers from the prosecution witnesses through cross-examination to dispel any such doubt. He may also adduce other evidence when he is called upon to enter on his defense. In other words, if circumstances appearing in the prosecution case or in the prosecution evidence are such as to give reasonable assurance to the court that the appellant could not have had the knowledge or the required intention, the burden cast on him under section 35 of the Act would stand discharged even if he has not adduced any other evidence of his own when he is called upon to enter on his defense, my lord. The first two circumstances, my lord, those are in my support, and I would like to, my lord, place the circumstances before your lordship. Now, my lord, another decision is same month. Next case, man, Bahadur Singh versus State of Madhya Pradesh. Paragraph 8. Paragraph 8 there, Madam Bahadur Singh. Well, here is a case that there were only police witnesses, no independent witness, my lord. Here is also a case, my lord, in my humble submission, there is no independent witness, my lord. Under the aforesaid circumstances, the appellant cannot be convicted on the sole testimony of police witness, PW3.
That is complete violation of the procedure which is envisaged under the section 50 or whatever.
Yes, my lord. 50, my lord.
Complete violation.
Yes, my lord. The primary evidence
has nothing to do with 35. If 50 is violated, for instance,
first two circumstances that is explained in the three judges, Mansoori, my lord. Mansoori case, my lord.
Yes. So this has no.
Even if I, my lord, don't adduce my evidence to say.
This says 35 has no operation in such a situation. Because 50 is not established, it's not established.
It is not.
35 has no operation.
Yes, ma'am.
You show 50 being breached over here.
Yes, with the Caesar, madam. Caesar also.
50 to the
Caesar. Now, my lord, Caesar, my lord. I'll just briefly outline, my lord.
Let us see the provision and then we'll go to the facts.
Yes, my lord. 52A, my lord. Of the Act. Disposal of seized narcotic drugs and psychotropic substances.
This is disposal.
Yes, madam. That is how they, my lord, on seizure, my lord, they have to make an inventory, take it to the magistrate
later. Has 50 been breached?
Yes, madam.
Has 50 been complied with?
No, not complied with, madam. It is
conditions.
My submission is that it is not complied.
Why are you going to disposal?
Yes, madam.
You are going to disposal, presupposes 50 has been complied with.
No, madam. 50
has not been recovered from you in accordance with law.
Yes, madam.
Then disposal does not arise.
Yes, madam. Correct, madam.
Yes.
Section 50, my lord, I'll read out. Conditions under which search of a person shall be conducted. When any officer duly authorized under section 42 is about to search any person under the provisions of section 41, section 42 or section 43, he shall, if such person so requires, take such person without unnecessary delay to the nearest gazetted officer of any of the departments mentioned in section 42 or to the nearest magistrate. And my lord, then the follow-ups, if such requisition is made, the officer may detain the person until he can bring him before gazetted officer or magistrate referred to so and so. the gazette officer or the magistrate before whom any such person is brought shall, if he sees no reasonable ground for such, forthwith discharge the person, but otherwise shall direct that such be made. My lord, here is a case where, my lord, they were coming in that scooter and they were stopped.
Up to 5?
My lord, yes. When an officer duly authorized under section 42 has reason to believe that it is not possible to take the person to be searched to the nearest gazetted officer or magistrate without the possibility of the person to be searched, parting with possession of any narcotic drug or psychotropic substance or controlled substance or article or document, he may, instead of taking such person nearest gazetted officer, proceed to search the person provided under section 100 of the Code of Criminal Procedure. This is all right, my lord. My lord, what their case is, my lord, there was a magistrate present, my lord, but she was on an election duty, so she couldn't have been, and that fact was not explained to the accused that I am making this search in front of a magistrate. That was not done. Without letting him know that a magistrate is there, it was not very good.
50 we have seen. Then you want to show us 50A or 52A?
52A. The central government may, having regard to the hazardous nature, vulnerability to theft, substitution, constraint of proper storage space or any other relevant consideration in respect of any narcotic drugs, psychotropic substances, controlled substances or conveyance, by notification in the official gazette, specify such narcotic drugs, psychotropic substances, controlled substances or conveyance or class of narcotic drugs, class of psychotropic substances, class of controlled substances or conveyances, which shall, as soon as may be after their seizure, be disposed of by such officer and in such manner as that government may from time to time determine after following procedure hereinafter specified. 2. Where any narcotic drugs, psychotropic substances, controlled substances or conveyances has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53. The officer referred to in subsection 1 shall prepare an inventory, which was not done in this case, of such narcotic drugs, psychotropic substances, controlled substances or conveyances, containing such details relating to their description, quality, quantity, mode of packing, marks, numbers, or such other identifying particulars of the narcotic drugs, psychotropic substances, controlled substances or conveyances, or the packing in which they are packed, country of origin, and other particulars as the officer referred to in subsection 1 may consider relevant to the identity of the narcotic drugs, psychotropic substances, controlled substances or conveyances in any proceedings under this act, and make an application to any magistrate for the purpose of certifying the correctness of the inventory so prepared, or taking in the presence of such magistrate photographs, substances of conveyance, such drugs, and certifying such photographs as true, or allowing to draw representative samples of such drugs or substances in the presence of such magistrate, and certifying the correctness of any list of samples so drawn, where an application so and so the magistrate shall, as soon as may be, allow the application, notwithstanding anything contained in the Indian Evidence Act or the court of every court trying that this will be regarded as primary offence. Now, none of this have been given a total go by. No inventory, no taking to the magistrate, no certification from the magistrate of the seizure and the inventory, and no sample was taken in her presence, no marking, my lord. The evidence, my lord, I will place my lord, that will clarify, my lord. So there is a breach in the entire process, my lord. And more than that, my lord, safe custody, my lord. There was no safe custody at all, my lord. It was not taken to the officer in charge. There was no record for 4 days where the material was contraband, at least contraband was.
Was it produced at the trial?
Not produced, my lord. One sample was brought. One sample was brought without forwarding letter from the police officer to the FSL. And the charge sheets were not produced, my lord. And very strange, my lord. The first charge sheet was filed on a day after receipt of the FSL. Thereafter, a supplementary, my lord, they said that they will file a supplementary charge sheet, but only the FSL report was produced.
Yes.
Section 57, 57. Mangkhana Mang.
My lord, I would just like to take your lordship to, my lord, to treat other sections, my lord, 55
And 57.
57, my lord, on this, my lord,
42 plus.
of the act. Police to take charge of articles seized and delivered. My lord, this is a very stringent act, my lord. The minimum, my lord, penalty is 10 years plus fine, my lord. An officer in charge of a police station, I am reading out 55, of a police station shall take charge of and keep in safe custody, pending the orders of the magistrate, all articles seized under this act within the local area of the police station and which may be delivered to him, and shall allow any officer who may accompany such articles to the police station or who may be deputed for the purpose to affix his seal to such articles or to take samples of and from them, and all samples so taken shall also be sealed with a seal of the officer in charge of the police station. All these provisions have been violated, man. Then 57, man. Report of arrest and seizure. Whenever any person makes any arrest or seizure under this act, he shall within 48 hours next, after such arrest or seizure, make a full report of all the particulars of such arrest or seizure to his immediate official. No production, my lord, no report. No report was produced. Now, my lord, I'll just take your lordship to once, my lord, which is also very really 42. It gives power of entry, such seizure and arrest without warrant and authorization, my lord. 42(2), subsection 2. Even if it was a, my lord, they want to say it was sun's recovery. They were checking vehicles. Because next day was the election day. Then this thing happened, my lord. And it happened in a road junction, my lord, very public place in the middle of the day. And there was no independent witness. 42(2). Where an officer takes down any information in writing under subsection 1 or records grounds for his belief under the provision thereto, he shall within 72 hours send a copy thereof to his immediate officer, which is not done in this case. Not produced. Now, man, for once, man, I would like to take your lordship to the 313 statement. Man. Then I will come to the evidence around. Before that, man, Mohanlal's judgment, I would like to take your lordship. That is in the, what is it? It mainly is no.
2018-17 SCC.
2018-17 SCC, exactly, madam. Mohanlal, para 12. This is also 3 judgments, madam. May I just read out, madam? Para 12. Unlike the general principle of criminal jurisprudence.
Justice, sir.
My lord. Serial number 5.
Yes, sir.
Paragraph 12.
Yes.
But para 12 I just like to read out.
Yes.
Well, paragraph 12, man. I'd just like to read out, man.
12.
Yes, man. Mohanlal, man. Unlike the general principle of criminal jurisprudence that an accused is presumed innocent unless proved guilty, the NDPS Act carries a reverse burden of proof under Section 35 and 54. But that cannot be understood to mean that the moment an allegation is made and the FIR recites compliance with statutory procedures leading to recovery, the burden of proof from the very inception of the prosecution shifts to the accused without the prosecution having to establish or prove anything more. The presumption is rebuttable. Section 32 provides that a fact can be said to have been proved if it is established beyond reasonable doubt and not on preponderance of probability. The stringent provisions of the NDPS Act, such as Section 37, the minimum sentence of 10 years, absence of any provision for remission, do not dispense with the requirements of the prosecution to establish a prima facie case beyond reasonable doubt after investigation, only after which the burden of proof shall shift to the accused. The case of the prosecution cannot be allowed to rest on a preponderance of probabilities. Then my lord, a comparatively recent case, my lord, 2020, my lord, 16 Supreme Court cases. Serial number 6 of the branch your lordship is handling.
Yes.
My lord, here also it speaks about Section 35 and 54, my lord. Presumption of culpable mental state, reverse burden of proof, etc. My lord. Paragraph 8 and 9
Of
of my lord 2020-16 Hanif Khan alias Anu Khan, last judgment in that bunch. Not last, my lord, this is serial number 6. 6 in that bunch. Para 8 and para 9. Serial number 6. I'm reading out now. Paragraph 8. We have considered the submissions on behalf of the parties. The prosecution under the NDPS Act.
Just one minute. Yes.
We have considered the submissions on behalf of the parties. The prosecution under the NDPS Act carries a reverse burden of proof with a culpable mental state of the accused. He is presumed to be guilty consequent to recovery of contraband from him. And it is for the accused to establish his innocence, unlike the normal rule of criminal jurisprudence that an accused is presumed to be innocent unless proved guilty. But that does not absolve the prosecution from establishing a prima facie case only whereafter the burden shifts to the accused. Then it quotes from the Nuroga. Nuroga is also in the other bunch. 58. Sections 35 and 54 of the Act, no doubt, raise presumptions with regard to the culpable mental state on the part of the accused, as also place the burden of proof in this behalf on the accused. But a bare perusal of the said provision would clearly show that presumption would operate in the trial of the accused only in the event the circumstances contained therein are fully satisfied. An initial burden exists upon the prosecution, and only when it stands satisfied would the legal burden shift. Even then, the standard of proof required for the accused to prove his innocence is not as high as that of the prosecution. This is very important. Whereas the standard of proof required to prove the guilt of the accused on the prosecution is beyond all reasonable doubt, but it is preponderance of probability on the accused. If the prosecution fails to prove the foundational facts so as to attract the rigors of section 35 of the Act, the actus reus, which is possession of contraband by the accused, cannot be said to have been established.
9.
Then 9, my lord. Because there is a reverse burden of proof, the prosecution shall be put to a stricter test for compliance with statutory provisions. If at any stage the accused is able to create a reasonable doubt as a part of his defense, to rebut the presumption of his guilt, the benefit will naturally have to go to him. Now here is a case, my lord, that was seized from the person of the pillion rider, my lord. And there is not even iota of evidence, my lord, to establish the link between the they had seized our phones. They could have got call detail reports and registers, CDX. That could have been examined, my lord, if there was any link, whether we conspired and all that. Nothing was done, my lord. It was both the phones are within their custody, my lord. Then, my lord, I will also kindly come to 313 statement, my lord, of the paper book, page 52. Both the accused were asked questions separately under section 313. 52 is relating to the present appellant, madam. Page 52, madam. Page 52. Is Sancte Paite, madam. I'll not take long, madam. Just two questions also. PW PW1, question 1, PW1 Sri Kesinath. He is also the informant. Second, I see Nongthimai Beat House stated that on 22/2/2013, he was conducting vehicle checking along with his staff. Magistrate Srimati P.K. Sangma and one photographer C.F. Kaji, who was deputed by the District Election Commissioner for election duty at around 1:15 p.m. Detained one scooter, red color, registered number ML05G5583.
That should be there.
I'll pause for a moment, Mala. Even this number is incorrect, Mala. I'll place it. And on checking, found one bag, blue color, full of spasmopoxyphone capsules from the possession of you, the rider Sri Sangtepaiti, and pillion rider Sri Lalming Liana. He then informed SP and additional SP who deputed ANTF, and on arrival of the ANTF has made the seizure. Exhibit 1 is the FIR lodged by him, and Exhibit 2 is a seizure list of 1. 2 bundles of spasmopoxyphone capsules, and each bundle contains 180 strips. Each strip contains 8 capsules. Number 2, 7 bundles of SP contain 18 strips each. 3, 2 bundles of SP capsules containing 15 strips each. 4, 18 strips of spasmopoxyphone. Then 1 blue color carry bag, noted adventurer, and scooty as well as your mobiles. 1 blue color carry bag, noted PW1 confirmed the seized items as material exhibit 1 being the 531 strips of SP capsules, material exhibit 2 as the carry bag, and other material exhibit as thereafter, and thereafter SIS Sangma prepared punch number. Exhibit 3 PW1 further stated in course that they recovered the drugs from pillion rider Lalming Liana, and that the scooty was coming from Loinsville Road towards IIM Junction. What do you have to say? Which I denied, but I do not know anything. It is not my bag. Meaning it was his bag, so I do not know. I didn't have knowledge. So defense witness, man, whether it will be necessary after this, man.
Are you joking?
My lord, I'm just making a submission, my lord. Yeah, I cannot go beyond this.
Seriously arguing this.
My lord.
Your answer is I don't know anything, and that is proved beyond reasonable doubt.
My lord, this question posed to me, my lord, and he...
Yes, the blue bag was recovered from the scooty.
From the pillion, not the... From
where is it from the... Please don't put words into the...
No, my lord, you will see
a blue bag...
Yes. From the pillion rider.
Big noted as well, one blue color bag noted adventure and scooty as well as your mobiles has been confirmed seized. Where does it say from the pillion rider?
PW1 further stated in the course that they recovered the drugs from pillion rider Lalming Liana.
PW1?
Yes, ma'am. Informant. And seizing of...
They recovered the drugs.
Yes, ma'am.
And then scooty was coming. The one blue color bag and scooty. Drugs may have been from thing, but one blue color bag and scooty.
Your Lordship will kindly come to the last sentence, ma'am.
Let us see the evidence.
No, yeah, I'll definitely, Your Lordship. Last but one. PW1 further stated, as Your Lordship got.
Yes.
In the cross that they recovered the drugs from pillion rider Lalming Liana, who is a co-against man.
Yes.
Not from me. And that the scooty was coming from so-and-so road towards IIM Junction.
Yes.
So, it is their case that the drugs was seized from the pillion rider, because that one bag cannot be carried by 2 persons, man.
Yes.
That was black.
And if I am driving, my bag cannot be carried by me also?
That has
It is small bag. We do not know, my lord, that they have to explain how big it was. If it is a suitcase, then it's a different case. If it is a bag, my lord, slung on the soldiers, my lord.
Nothing.
And that vehicle number, my lord, it should have been, I have also checked with this thing, my lord. Seizure list, my lord.
I have not said anything about that, my lord. You have admitted the vehicle. You have admitted the seizure. You say, I do not know anything, it is not my bag. The moment you say it is not my bag, means that there was a bag, but that bag was not mine. After such statement, it does not lie in your mouth to say it was not the same scooty, the scooty number is wrong. You have said it is not my bag.
My lord.
It is not my bag means it is not my bag. But it is an admission that there was a bag.
No, my lord, they said that Lalmi Luana is carrying, my lord. It was seized from him. So I said, my lord, I am a Mizo boy, my lord. My English couldn't have been very perfect, my lord. They do not show that I have been.
May not have been.
Yes, my lord.
You will ruin the world with the drugs, but when it comes to prosecution, then all advantages.
My lord, there is
nothing.
There is
Let us come to the evidence. Let us come to the
Yes, my lord.
You want to make a mockery of the law.
Absolutely not, my lord. I am just placed the law, my lord. Your lordship will decide as a discussion. Go to EW1. 30. Page 31, your lordship will kindly come to.
31.
Yes.
Yes.
Madam, your lordship will kindly note that he is a seizing officer. As a policeman, he is also the informant. He is also the informant. And our Panchnama. Yes, madam. During February 2013, I was posted at Montri, my beat house, as second IC. On 22/02/2013, I was conducting vehicle checking along with my accompanied staff, Magistrate Srimati P.K. Sangma, and one photographer, C.F. Kaji, who was deputed by the District Election Commissioner for ongoing election duty. During checking at around 1:15 p.m., we have detained one scooty bearing registration number ML05J5583 red color. So there it was mentioned otherwise. And while on checking, we found one carry bag, blue color, full of in short, I'm saying SP capsules. From the possession of one rider, Sri Sankte Paite, and Pillion rider, Sri Lalming Liana. Accordingly, we have informed the matter to SP and Additional SP East Khasi Hills, Shillong, and who deputed the Anti-Narcotic Task Force for taking necessary action. After arrival of the Anti-Narcotic Task Force, I had made the seizure also. Exhibit 1 is the FIR lodged by me, and Exhibit 1/1 is my signature. Exhibit 2 is the seizure list prepared by me, and Exhibit 2/1 is my signature. Then my list of the drugs. 2 bundles of SP capsules.
Produced in court.
Not produced, madam. Not produced.
Please read page 32.
Page
32.
Yes, madam. Reading, madam. The sealed packet is open today in the court, and I recognize the seized item. Material Exhibit 1 is 531 strips of spine. My lord, I'll come. Material Exhibit 2 is the said carry bag. Material Exhibit 3 is Nokia Mobile X2 seized from Sankte Paite, and Material Exhibit 4 is another Nokia Mobile seized from Lalming Liana.
So all produced in court.
Yes, madam. After making the After making the above seizures, I handed over the seized articles to SI SS Sangma, IC Narcotic Cell, who had prepared the Panchnama, which is Exhibit 3, and I had signed as a witness my signature in Exhibit 3/1. Then cross-examination, madam. On that day, we have checked a number of vehicles, but we could not keep the record of the vehicles checked on that day. We recovered the drugs from the pillion rider, namely Lalming Liana. He is very clear, madam. From the scooty, we did not find anything. He is also clear from that. The personal search was conducted, and from the physical body of the accused person, nothing was found except the bag which one of the accused person was carrying. So they have conducted personal search also, not taken to magistrate. Material Exhibit 2 is available in the market. In the market, I have not made any. It should be different. I have not put any identification mark on Material Exhibit 2. It is not a fact that Material Exhibit 2 is not the bag in which the drugs were carried. I haven't mentioned in my seizure list how many pockets the bag Material Exhibit 2 contained. It is a fact that I have not mentioned how many drugs were recovered from each pocket. In this case, I am the seizing officer. It is a fact that identification mark has not been given on each strip. It is a fact that I have not mentioned in my seizure list the manufacturing dates and price of the drugs on each strip. I have also not mentioned after the expiry dates of the drugs on my seizure list. It is not a fact that the drugs were not recovered from the possession of the pillion rider. The scooty was intercepted at 1:15 p.m. on that day, and it is only on arrival of the anti-narcotics task force that I prepared the seizure list. I prepared the seizure list on being instructed by my senior officers, additional SP. The exhibit 2 was not signed by any officials from the anti-narcotic task force. It is a fact that it is not mentioned in exhibit 2 that it was prepared only on the arrival of the anti-narcotic task force and additional SP. I have filed exhibit 1 to the OC officer in charge, Nongthimai Beat House, under the instructions of my senior officer. I filed the FIR at 5:45 p.m. and on the same day, and I do not know when the case was registered except the GD entry was made at the same time. It is a fact that after seizing the drugs and completing all the formalities, the FIR was filed. It is a fact that the investigation started then and thereafter only FIR was filed. I didn't take part in the investigation of the case. It is not a fact that the accused persons were falsely implicated in this case. I came to know through the government notification that spasmoproxivone is a banned drug, and I cannot give notification number to show that spasmoproxivone is a banned drug. It is not a fact that the drugs were seized on having specific information. After seizing the drugs, I handed over the same to Mr. S.S. Sangma, IC Narcotics Cell, and he has taken custody. So PW1 was not aware of the drugs after seizure. He handed it over. I do not know where he had taken the drugs, but it was not taken to Nongthimai Beat House. It was required to be kept in the local police station under the supervision of the OC. At that time, one Mr. M. Limbai was in charge of Nongthimai Beat House. The IC of Nongthimai Beat House did not play any vital role in this case except for forwarding the FIR to India, but he has not been examined. I cannot say whether the seized drugs were kept either in Malkhana or police station. Then another cause, there were 2 accused. I have no prior information in regard to accused Lal Ning Liana. The scooty was coming from Lojinmuri Road towards IIM Junction. The checking was started from 12 noon. The area is a busy road. No other materials were found except for the drugs from the bag, material exhibit 2. The signature of the accused is there on the packet where all the material exhibits were packed and sealed. The signature of the accused is there on the seizure list. The photographer is C.F. Kaji, is a government employee deployed by the district election commissioner. The seizure was prepared at 1:45 p.m. It is not a fact that all the drugs that were exhibited before the court today cannot fit in the bag. That is material exhibit 2. It is not a fact that the rider cannot carry a bag while riding a scooty. It is possible even if a rider is carrying a bag for one pillion rider to sit in the scooty. Now PW2, my lord, who was also on election duty, and he was a videographer and he videographed. Page 35. On 22/2/2013, I was performing the duty of photographer with the magistrate P.K. Sangma at Nongthimai near IIM. The police were conducting vehicle search, and during the search of the vehicles, they intercepted one scooty on which one boy having one bag in which the police found plenty of drugs. Thereafter, the police informed the SP and other authority concerned, and when SP and others reached on the spot, seizure was prepared and seized materials were kept in a carton. No carton was ever produced, my lord, not exhibit, nor exhibited. I have signed exhibit 2 as a witness, and exhibit 2 is my signature. I have signed the panchrama also, that is exhibit 3, and exhibit 3/2 is my signature. On the carton box, that is the master packet, I have put my signature as a witness. I recognize material exhibit 1, which are the drugs seized by the police, and material exhibit 2 is the carry bag in which the drugs are kept. I can identify the accused persons who are standing in the dock. The witness pointed to Sancte Python Life, so he identified. On the spot, also I did videography. This is very important. Of the event and submitted the same to the magistrate. Your Lordship will kindly note. Cross-examination by M.F. Qureshi, advocate for the accused, Sancte Paite. I do not remember from which particular accused the bag containing drugs was recovered. Number one, man. I do not know if any identification mark was given on the bag. I did not examine the bag personally. I do not know what kind of drugs were seized by the police, and I was not informed by the police about the drugs. I didn't see whether the police had put any mark on its strip. It's a fact that I cannot say whether it is the same drugs, but I can say that those drugs were kept in the carton box which I have signed. I do not know how many strips were seized in this case. I cannot say the numbers of capsules and strips seized. I cannot say whether the same drugs were available in the medical store. The carton was brought by the police. It is a fact that on the body of this carton was never exhibited. It is a fact that on the body of the master packet, the name of the drugs was not mentioned. I do not know what is a panchnama. I signed Exhibit 2 and 3 on being asked by the police. My statement was never recorded by the police in this case. Your Lordship will kindly know his statement itself was not recorded, my Lord. And the trial court relied on the evidence of 1, 2 and 7, my Lord. Basically, I'll come to the other evidence. The police never requested me to give them the video clipping to them. This is also very important. I do not remember if the copy of the scissor list was given to the accused persons. Before signing, I didn't go through the contents of Exhibit 2 and Exhibit 3. FIR and punch number, Exhibit 2 and Exhibit 3. I do not know what is written. The drugs was taken by the police. Cross-examination. I was there from 11 a.m. at IIM Junction at Nongtimai. I remember seeing only the drugs which were placed on the scooty on that day. I do not remember the numbers of police who are doing checking on. I have not seen other materials from the bag. That is material Exhibit 2 except the drugs. Then 3 and 4 are the two constables who accompanied the IO. Page 37. I joined the police service in the year 1999 as EUB constable. I had been posted in the Special Cell Crime Branch SP's office, Shillong, since 2007. It was on 22/2/2013. I was busy. I was in my office along with my senior officers. Our in-charge SISS Sangma asked me to accompany him to go to Nongtimai, Shillong. After reaching the PO, I found the sector magistrate along with the police personnel of Naka party were present there. They informed SISS Sangma that they have intercepted one scooty along with the rider and the pillion rider. They had been searched by the police officer in the presence of the magistrate, and 2 packets of parcel in one bag was found. And in those 2 packets, capsules were there. Those articles were seized and packed by SISS Sangma in our presence. A punchnama which is Exhibit 3 was prepared by SISS Sangma, and I have also signed the said punchnama. Exhibit 3/3 is my signature. I can identify both the accused persons who were apprehended on that day who are present in the court today. Then cross-examination was different. 39, page 39, madam. I haven't seen when the scooter was intercepted, but I was informed by the in-charge. The in-charge SISS Sangma has prepared the punchnama and the PO. I have not gone through the contents of the punchnama, which is Exhibit 3. I do not know what is written in the punchnama, but the in-charge has explained the contents of Exhibit 3. It is a fact that the seized drugs have not been produced in the court today. I have not signed any seizure list. I cannot say at what time I reached the PO. And then by the other accused, when I reached the place of occurrence, the accused was standing in the other side. That you also may also note, but they were not trying to flee away, they were just standing there. Which my lord, habituated criminals will never do, my lord. Then 4, my lord, page 40. This is another constable. There were two constables, my lord, 3 and 4, accompanying 5, the IO, from the narcotics department, man. This is the next one, man. He is important, man. I joined the police service on 5th of November 2001 as UB constable. I am posted in the Special Cell Crime Branch SP's office, Shillong, since 2007. I know of this case. It was on 22/2/2013, our officer SIS Sangma got information that 2 persons had been intercepted at IIM Junction, Nongthimai, Shillong. I was asked by my officer to accompany him, and after reaching the PO, all the formalities were done by my officer, and I was asked to take photographs of all the events. I had taken photographs of those 2 persons who had been intercepted by the police there. SIS Sangma had prepared the Panchnama and I had signed the same exhibit. 3 is the same Panchnama and exhibit 3/4 is my signature. I can identify both the accused persons who are present in the court today. So this witness also photographed after they arrived in the place. He is another official photographer. Then page 41, cross-examination. I didn't see when the scooter was intercepted, but I was informed. But they came later. This is quite normal. Then I was informed to go to the PO to take photographs. It is a fact that I have not taken part in the formalities except for taking of photographs. I have given the photographs to the IO. It is a fact that the photographs that I have taken is not produced in the court today. I do not know who has prepared exhibit 3. I do not know what is written exhibit 3. Then, my lord, exhibit 3 is a Panchnama. I cannot remember the time when the scooter was intercepted. The seized materials are not produced in the court today. So, except perhaps for the PW1, the informant, the seized materials were never produced in the court by aftermath. PW5, my lord, at page 42 is the IO. He is Sim Sang Sangma. At the relevant time, he was a sub-inspector of police. I was the IO of this instant case. It was the 22nd of February 2013. I received telephonic information from the then additional SP crime that SI Kesinath, along with the magistrate, had caught some persons along with psychotropic substances at IIM Junction, Nongthimai, while conducting vehicle checking in connection with the state assembly election. I was instructed by the additional SP crime to proceed to the PO. I, along with my staff, immediately proceeded to the PO. On arrival at the PO, SI Kesinath informed that they have detained 2 persons while conducting vehicle checking from scooty bearing registration number ML05J5583. Persons namely Sri Sanktepaita and Sri Lalming Liana had recovered 1 blue color bag containing spasmopraxivone capsules, which was carried by Sri Lalming Liana, who was a pillion rider. I accordingly asked Sub-Inspector K.S. Nath to prepare a seizure list, as it was a chance recovery and was recovered by him, and as it was a chance recovery, hence I had not obtained any authorization. The following articles were seized: 180 strips of SP capsule wrapped in Bengali newspaper. A previous witness had said it was in a carton gone. Now it comes Bengali newspaper. Your lordship will just keep that in mind. Then again, 7 bundles of SP capsule wrapped in Bengali newspaper. Then again, 2 bundles of spasmoproxivone capsules wrapped in Bengali newspapers. Each bundle contains 15 strips and each strip contains 18 strips of so-and-so. A novel. 1 Nokia X2 mobile of Sri Sanktepaiti with Airtel SIM card and 1 Nokia dual SIM card with 2 Idea SIM cards of Lalming Liana and the scooty. So they had all the material to establish the link, which they didn't do. After that, I took out control sample, and thereafter, with the help of my staffs, the seized articles were packed and sealed at the PO. Now, my lord, in the list of the material seized, my lord, there is a major discrepancy with the seizure list, my lord. There is a variance of 1440 capsules.
Where?
Here, my lord, this list and this seizure list, if we compare, my lord, if we add the numbers given, my lord, Both the lists are variance, my lord. Here it is less by the IO, PW5 by 1440. But if necessary, my lord, I can make a calculation, place it before Lord Smith. They have prepared a Panchnama which is Exhibit 3. Exhibit 3/5 is my signature. Thereafter, we took both the accused persons to Nongthimai Beat House, from where both the accused persons were sent for medical examination and a cognizable case was registered against them. During investigation of the case, the control sample were sent to FSM. I had submitted the charge sheet against both the accused persons, and after receipt of the FSL report, I submitted the supplementary charge sheet, which is not so. These are not produced and not exhibited by the prosecution. The charge sheets. The charge sheet and the supplementary, madam. Which are part of the record, madam. Also, they have not identified, the signatures are not marked. As it charge sheet to the court, as in the FSL report, it has given positive test for dicyclomine, acetaminophen, and dextropropoxyphene. Then again, material exhibit is the 531 strips of spasmopoxyphene. Material exhibit 2 is the blue color carry bag. Material exhibit 3 is the Nokia X2 mobile. Material exhibit 4 is the Nokia dual SIM card mobile. I can recognize both the accused persons, Sri Sankte Paite and Sri Lalming Liana, who are present in the court dock today.
Yes.
44 cross. Then this is the cross examination of 44. Page 44 of PW5, my lord. Page 44. The accused were not forwarded to the court for recording of their confessional statement by the magistrate. He is clear, my lord, and specific. We could not ascertain from whom the drugs was procured. The IO says that. It is a fact that I have not reflected anywhere in the charge sheet that the accused persons were having any knowledge about the drugs found inside the bag. And very surprising, he doesn't also speak of the source, my lord, from where they had taken the drugs and where they were carrying, my lord. They could even have taken these accused, my lord, to their residences to carry out a search. That was not done. Source is not disclosed. They never, very casual, my lord, they never cared, man. It is a fact that it is the first time.
The arrival of the anti-narcotics trafficking team.
Yes.
Wouldn't that be substantial compliance with Section 50?
Not so, my lord, that they have to be taken to magistrate, my lord. It is not complied with.
Yes.
It is a fact that it is the first time the accused persons were arrested in connection with this case. I have ascertained that both the accused persons are of 20 years of age. It is a fact that accused Sankte Paite was a student. The accused person stated that the bag was given to them by one person at Dhanketi. The accused also did not know the name of the accused person. I agree that the drugs seized in this case, Spasmo, is available at the medical stores. It is not a fact that Spasmopoxyphene does not fall under NDPS Act. It is not a fact that I have not mentioned at the time in Exhibit 3. It is a fact that there is some overwriting in Exhibit 3. Exhibit 3 is the Panchnama. It is a fact that Exhibit 3 is based on the statements of independent witnesses who are, now your lordship will kindly note this, madam. Is based on the statements of the independent witnesses who are the magistrate ESC Sri P.K. Sangma and one photographer C.R. Kazi. They were deputed by the election department along with the police personnel to carry out Naka, my lord. How could they be, my lord? Independent witnesses, my lord. And he had photographed, my lord, the C.R. Kazi, the PW2. And magistrate is the PW7.
So the magistrate was there.
Magistrate was there, but officially they were actually not an independent witness, with the police team, my lord. Your lordship is aware, my lord, before election, my lord, bags and all are checked for some other purpose.
This one man, PW1, found you?
Yes.
After that, PW1 contacted the superiors. They contacted the anti-narcotic trafficking, anti-narcotic team, And then these people came.
my lord.
They came to the site where you had seized.
Yes.
And they saw the material, whatever it is there, they are testifying to it.
My lord, my lord. Correct, absolutely correct.
Yes.
My lord. It is a fact that Exhibit 3 is based on the statements of independent witnesses who are the magistrate ESC Srimati P.K. Sangman, one photographer C.R. Kazi. SI K. Sinha has filed the FIR. It is a fact that after completing all the formalities, the FIR was filed. It is not a fact that I have not mentioned in the charge sheet the formality observed by us. I was not present in the spot when the vehicle was intercepted by SIKC Nath. I reached the spot at 1:30 p.m. on 22/2/2013 and the seizure list and punch number were prepared at 1:45 p.m. on 22/2/2013. It is not a fact that we have completed preparing the seizure list and punch number within 15 minutes, but we have started and the seizure list was not prepared by me. The whole case is based on the statement of SIKC Nath, who is PW1. By the time the vehicle was intercepted, there was one magistrate and one cameraman from the election department. As per the statement of the magistrate and cameraman, they had seen the drugs inside the vehicle. My lord, the magistrate had said it was seized from the vehicle, which is again wrong, my lord. The others not corroborate. So that is a page. I will take a loss in there. It is a fact that none of the strips of spasmoproxivone capsules bear any of our identification mark. It is a fact that I have given the complete description of each strip, such as manufacturing date, expiry date, and the prices. This is again not corroborated, man. And I agree that these medicines, spasmoproxivone, are available in a medical store. It is also a fact that color of the capsules were not mentioned in the seizure. It is not a fact that material exhibit are not the same capsules which were seized on the spot. I don't know how many packets are there in material exhibit 2. And same have not been reflected in the exhibit 3, Panchanama. On being shown to me the material exhibit 2, seizure list, there are 5 packets altogether including material exhibit 2. The entire strips of capsules recovered from the second packet of material exhibit 2 and other packets were empty. And I have not reflected this in exhibit 3. It makes it all the more doubtful, man. It is not a fact that the strips spasmoproxivone were not recovered from material exhibit 2. I do not agree that the drugs were planted by us to implicate the accused person. After the seizure of the material exhibits, we kept in the office of the Anti-Narcotics Task Force. This should have been placed in a local police station, madam. That is in the Malkhana of the local police station, madam. The material exhibits were in my custody till it was sent to the court on 23/2/2013, that is the next day. And to the FSL on 26/2/2013. So there is every, my lord, from 22 to 26/3, but these 4 days, my lord, it was with him, and there is every scope of manipulation, or tempering, my lord. That will be the perfect word. That should have been taken straight to the Malkhana, my lord. And Malkhana register is also not produced. I have not stated the reasons for the delay in sending the material exhibits in FSL. He is very candid himself, my lord. He has not explained, my lord. I do not have any document to show that I was authorized to retain the custody of the material exhibits, but the official order is there in the office. It was not brought to the court. If at all it was there, we don't know. It is not a fact. But both the standing order 1 of 89, my lord, which was earlier there, prior to the Mohanlal, my lord, all these steps have been violated, my lord. And section 55 and 57 of the Act. It is not a fact that material exhibits were tempered and manipulated while they were in my custody. The statements of the witnesses were not recorded by the magistrate under 164 CRPC. It is not a fact that the accused persons were falsely implicated in this case. It is a fact that none of the strips bear the signature of the accused person and the witnesses, but they have signed in the seizure list and master packet and control sample packets. It is a fact that, and again, my lord, the control sample packets were not produced, man. Cartons not produced, Bengali newspaper not produced, and control sample not produced, and my signatures were never collected. It is a fact that packet shown to me today is the FSL packet, and my packet is inside the FSL packet, which is not produced. It is fact that the control packet was not opened during my examination shift and today. So the control packet was not opened. So it remained in dark what was there. It is a fact that the signature of the accused persons and the witnesses are not visible since the packet is inside what
he said. Control packet was not opened during my examination of today.
Yes.
Has he anything to do with the contents of the control packet?
Well, he is the IO, my lord.
He is the IO.
He can show the forwarding to the FSL.
No, let's not go into. You're talking about control packet was not opened.
Well, he could have shown
this cross-examination was taking place when?
Cross-examination was taken place
in December.
March 2014.
March 2014. PW1 had been examined on 31st October 2013.
My lord.
When it was opened.
My lord.
PW1 proved
that
this was there, this was there, this was there. PW1 proved his signature.
My lord, they have to take everything beyond, my lord, reasonable. My lord, what I mean to say, my lord, if the packet was there, my lord, my signatures, whether it was collected there or not, because the FSL expert.
Very well. Let us see what the trial court has to say.
My lord. You also would like to go to the judgment, my lord?
Let us see. The thing, the chemist also says.
The chemist is at page 47, my lord. His cross-examination is important. I'll read the in-chief first, my lord. I am page 47. I am posted as Deputy Director as Chemistry Division in the Directorate Forensic Science Laboratory, Shillong since 2009. On 26/2/2013, a requisition was received by myself for examination of samples sent by the police, that is Additional SP Crime, East Khasi Hills District. The sample contains 3 strips of SP capsules, a total number of 24 capsules, and on its chemical examination, it gave positive test for dicyclomine, acetaminophen, and dextropropoxyphene. On 29/4/2013, I signed and submitted the report to the director and sent the same. Your Lordship will kindly note the dates. 29/4 he had sent it. Charge sheet was filed on 34 without the FSL report. I signed and submitted the report to director. Exhibit 4 is the said FSL report prepared by me, and Exhibit 4(1) is my signature. Material Exhibit 5 are the 24 numbers of spasmoproximone capsules, which was sent by me after examination to the Additional SP Crime, which had been marked by me as DN number so to DN 88913. Cross-examination by. I have been working in Forensic Science Laboratory since 1993 as scientific officer. I have dealt with hundreds of cases in regard to contraband items. Chemical contents of spasmoproximone in quantity are so and so, so and so, and so and so. I was endorsed by the police to examine the articles, whether it is narcotic drugs or not, and any other important points, and if so, describe the name of the narcotic drugs. Dextropropoxyphene is the only contraband which falls under the banned substances under the NDPSA. Then further cross-examination. I cannot say the time when I received the sample sent by the police on 26/2/2013. The spasmoproximone capsule is a composition of 3 chemical substances. Each capsule contains so and so, but I have not reflected in Exhibit 4 that each tablet contains 100 mg dextropropoxyphene. I have examined all the 24 capsules. From each capsule, I have taken some substance for chemical examination, but in Exhibit 4, I have not stated the quantity of substances which I took from each capsule. It is not a fact that I have not examined each capsule by taking out the substances from there, but it was intact when I received it. This plasmoproximon is available in the market on prescription. When I received the material exhibit 5, it did not bear the identification mark of the police, but it was sent in an envelope. Your Lordship will kindly mark it. The envelope in which material exhibits was sent by the police also didn't bear any number of police or tag number, except the signature of the IO and the witnesses. The envelope was not produced, madam. On the body of the envelope, the police has not written any date. I cannot say when the material exhibit 5 was sealed and packed in the envelope by the police. This envelope was neither produced or exhibited. And whether my signatures were collected thereon, we do not know. Because it was not drawn in front of magistrate, my lord. That is also another thing, man. That sample was not collected. Then, my lord, PW. PW 7, my lord, page 49. She was the magistrate, my lord, who was present with the team from the election department. Page 49, my lord. I joined the Meghalaya Civil Services in the year 2010, and my first posting is at East Khasi Hills, Shillong. And I am presently posted to Riboy district, Nongpo. On the 22nd of February 2013, a day before the assembly election, police team and I were there, and we were checking vehicles as a part of the assembly elections, when we intercepted one scooty which bear ML, but I could not exactly remember the number of the scooty. There are two male persons riding the scooty. After that, I have informed the DC election. So information has gone through her. Then the RO informed the additional SP, Sri Vivek CM. Then additional SP sends one SI by name of S.A. Sangma, who is the PW5. And they seized the strips of spasmoproximon from these two boys who were riding the scooty. S.A. Sangma has seized the contraband items from the possession of these two male persons, and I was a witness. Which is again not correct, man. Exhibit 2 is a seizure list dated 22/2/2013. Exhibit 2/3 is my signature. I have also put my signature in Exhibit 3, Panchnama, which is a Panchnama dated 22/2/2013. Exhibit 3/4 is my signature. Material Exhibit 1 is the 531 spasmoproximon capsule material. Exhibit 2 is the carry bag. Material Exhibit 3 is the Nokia X2 mobile. Material Exhibit 4 is the Nokia mobile. I can identify only one of the accused persons. Your Lordship will kindly note. Witness pointed to Lalming Liana. Page 50, who is standing in the court dock today. Then again cross-examination. The incident took place at around 12 noon time. There was no independent witnesses, she herself says, at the place of occurrence other than the videographer and the police persons. Now all of these are official witnesses. I cannot say who was carrying the black bag. Now she marks the bag as black, whereas the seizing officer says, and again the IO also says, it to be a blue bag. Material Exhibit 2. It is not a fact that the seizure list was prepared in the PS. Around 531 strips were seized which were packed in small packets. The police conducted the search of the accused persons. The drugs were seized, some from the scooty and some from the bag. This is entirely new version. I cannot say how many packets were extracted from the FSL examination. The preparation of seizure of the drugs and other formalities took almost 1 hour. The police personnel came and took away the drugs after formalities of the seizure was completed. No papers relating to the drugs were seized at the time of seizing the drugs. It is not correct to say that I was not present when the drugs were seized. Apart from the seizure, I do not know anything about. Then again, on further course manner, the seizure list was prepared by S.I. Kesinat. I could not remember the exact time, but it was in the afternoon. I have also signed in the seizure list. I had signed the seizure list at 1:45 p.m. Panchnama was prepared by S.I. Sangma. I have signed only in the Material Exhibit 1. I cannot remember the numbers of the vehicles checked on that day. I was on duty since 11 a.m. onwards. I cannot exactly remember the number of police persons who were on duty along with me on that day. Now the trial code, Material Exhibit 1, which is the contraband matter, was packed on the place of occurrence. My lord, I will just take your notes.
I could not arrest the person.
কোনখিনি বলেছে?
46.
Madam, page 46, your lords will kindly come for a moment, my lord. PW5, my lord, I was, my lord, cross-examination, last part, my lord.
Yes.
It is not a fact that I have not taken the signature of the accused person witness on my package. I could not arrest the persons who are running the racket, as the accused person could not give us description. It is a fact that no drugs of such kind either recovered from their physical possession or from their residence. This is very important, man. I have not examined the parents of the accused persons. That also he says. It is a fact that I could not say whether the accused persons are having good character or bad character. It is not a fact that this is a made-up case against the accused persons. It is not a fact that I have investigated the case half-heartedly. It is a fact that at the time of filing of the charge sheet, the FSL report was not yet available. So he admits, but FSL report was received before filing of the charge sheet. It is a fact that FSL report is very important for the instant case. The first charge sheet I have filed without FSL report was not sufficient to prove the case against the accused persons. But I have filed a supplementary charge sheet. But none of these charge sheets have been exhibited. The records show.
Yes.
No, my lord, then, my lord. Prosecution case, my lord, and as also held by the trial court, my lord, is based on the submission of the deposition of the PW1, 2, and 7, my lord. And Caesar, my lord, as I had already, my lord, submitted, my lord. Caesar, my lord. No inventory was prepared by the IO. Same was also not produced by prosecution to ascertain the Caesar. And whether recovery was made from the possession of appellant accused. Therefore, there is serious infirmity raising grave doubt about the Alice seizure. If the seizure is under suspicion, then Alice sample is also doubtful. Sample was not prepared, collected under the supervision of magistrate, which violates, my lord, that mandatory section 52A. Then PW1 Kesinath, my lord, I'm just reiterating. Page 32 in this cross-examination, it stated that personal search was conducted and physical body of both accused persons, nothing was found except the bag which one of the accused person was carrying. Clarifying in this cross further that it was the Lalmin Liana who was carrying the bag. He clarified. But nowhere did he mention that he had afforded an opportunity of being searched in front of a magistrate. That must be, my lord, that must be stated to the accused, my lord, that so and so is a magistrate. So whatever I am doing or I am going to do, my lord, this is before magistrate. That was not done, my lord. Nowhere in the evidence also it comes out. And that link was never established, my lord. Even if we are taken as a joint possession, my lord, where is the link, my lord? That they have to, by 313 statement, one question I have to, in the other questions I will place before lordship. That link was that you had conspired, or, but they had all the material in their hand. Mobile phones were there, very relevant, man. That they didn't examine. And only one Caesar list, my lord, that Caesar articles were produced only once, my lord, that PW1. the seizing officer. Other than that, my lord, it was.
Anything else?
My lord, my friend probably would like to address me. Thereafter, if necessary, your lordship will kindly give me liberty. Liberty to rebut if anything is necessary.
Yes.
So basically, my lord, I say, my lord, the violation of the procedure laid down, my lord, that is one.
Yes.
And 35, my lord, I have counted on them, my lord.
Number more of a section 50.
50, my lord.
Lordship may kindly come to the finding recorded by the trial court, my lord, that will answer all the pleas raised by him, my lord. Now, Lordship may kindly come down to page 84, my lord, of the judge. It's a chance recovery, my lord, there is no question of compliance of the action.
Yes.
Now, my lord, here it says decision reasons. Now, I'm reading, my lord, the paragraph markers 20. Whether this is a case of chance recovery and compliance of section 50 of the NDPS Act is not attracted. No. PW1 stated in his evidence, stated that on 22/2013 he was conducting vehicle checking along with accompanied staff, Magistrate Srimati P.K. Sangma, PW7, and one photographer, C.F. Kaji, PW2.
In chance recovery, 50 does not apply?
Definitely does not apply. That has been what has been, my lord, held by the apex court. My lord, the decisions, my lord, has been reflected on.
That's why he has emphasized on 35 and not on 50.
Well,
what about disposal? 52A?
well, this is disposal of his property, my lord. Disposal, my lord.
No. What about 52A and about it has not been disposed, it's been produced. What about no markings, no recording of the expiry date, batch numbers and things like that? How do you link it to this? The material produced in court, how do you link it with the seizure? Because the seizure list did not indicate all that.
Now, my lord, I'll take
even the chemist.
My lord.
Even the chemist referred to the test result, but the chemist also said that there was no marking so as to link it to the material exhibit. They had found a bag.
Well,
from the bag, certain quantity of drugs.
Well,
only the spasmoproxy one is the contraband.
Well,
the other stuff is not.
Well,
and it's about 4,272
well,
in number. That's the total. That's the contraband.
Well,
but whether this is actually the material which came out of the bag, where is that evidence?
now, my lord, so far as my lord, the seized material concerned, my lord, it was never contended, my lord, that it was never the case of the defense. Now, my lord, the prosecution has produced the material exhibits before the court, my lord, to show that these are the contraband which were seized, my lord. Now, it was never doubted, it was never raised. My lord, now, lordship may kindly come to the finding recorded by the trial court at page 88, my lord.
88.
My lord, it starts from 88, my lord. My lord, whether so-and-so number of proxy 1 capsules was recovered from the possession of the accused persons, and accused persons were in contrast possession and transporting so-and-so numbers of proxy 1 capsules. The above point for determination is the crux of the case. which will determine the culpability of the accused person. From the discussions above, it is established that this is a case of chance recovery, and both the accused persons were travelling in a scooty bearing registration number M05J5583 when they were stopped at IIM Junction, Nanthimai, for checking on 22/2/2013. The prosecution evidence are scrutinized under the light of arguments advanced by the rival parties. PW1 is the informant, a person who effected seizure, stated in his evidence that during checking at around 1:15 p.m., one scooty bearing registration number M05J5583, red color, was detained on checking on blue color carry bag full of one blue color bag full of plasmoproxy capsules were recovered from the possession of rider Sri Sangte Paite and pillion rider Sri Lalminglian. Accordingly, PW1 informed the matter to SP and additional SP Conceals Shillong, who deputed the anti-narcotic task force for taking necessary action. After arrival of the anti-narcotic task force, PW1 had affected the seizure right Exhibit 2, and Exhibit 2.1 is the signature. PW1 made seizure of the following articles, white Exhibit number 2. Now, my lord, it goes to tell these things, my lord. Now, if I can skip, my lord, I read to the true. The seizure article, along with illicit substances, was produced and shown to PW1 during trial. My lord, this is what vital, my lord. PW1 identified them, which has been exhibited as material exhibit. 531 strips of plasmoproxy 1, each strips contain 8 tablets. Material exhibit 2, carry bags. Material exhibit 3, Nokia mobile X2, says from the Samte Paite, and material exhibit 4 is another Nokia mobile, says from the Lam Blingna. Now, my lord, the PW1, my lord, has identified those contraband items, my lord. PW1 stated, my lord,
That identification cannot be accepted unless the identification matches with anything. For instance, will you be able to tell the difference between a strip of, let's say, discipline and another strip of discipline? There is no difference between the two.
My lord. This is because, my lord, this is a manufactured good. My lord, added in the case, this is a raw material and it can be changed.
No.
It is not a case, my lord.
Manufacture is even more difficult. Now, over there, you say that there were 4272 capsules of spasmoproxy 1. Unless and until you indicate what was the batch number or what was the date of expiry at the time of seizure,
my lord,
how can you identify that this is the material which was seized from them? It can be some other material.
No, but the tablet will be same, my lord. It is a brand name, my lord.
Brand name is same. I tell you that I took a packet of discipline from you. I actually did nothing of that sort, and I show a packet of discipline that I bought yesterday and I say I got it from you. So, for them to establish that these were the tablets which were seized at the time of seizure, there has to be some recording that batch number so and so and something, and then when you produce in court, batch number so and so is matching. In the absence of that, how do we take it?
No, my lord, when it was produced, my lord, it was at no point of time, my lord. The question was raised that these are not the capsules which are seized. Now,
it is not for them to raise that question. It is for you to establish this is the material that was seized from them.
Well, we produce those material.
They have produced the material. But you did not establish that this is the material which was, you produced some material. You apparently seized some material from them.
My lord.
They are not denying that.
My lord.
You also produced some material in court. They cannot deny that.
My lord.
But you do not establish the material seized from them was the material which was produced in court.
No, my lord, that is what we have stated in our evidence, my lord. These are the materials which were seized. Now, this is in oral evidence, my lord. But all the witnesses have said that these are the materials.
How this is seized? Just because witness says does not make it sacrosanct.
My lord,
it is proved by either expiry date or batch number or mark. At the time of seizure, let us say I put my signature on the tablet or on the strip. This is my signature on the strip. Show something which will link the seized article to the article produced in court.
Now, my lord, taking it from other angle, my lord, if it is to be thought for a moment, my lord, if we take it these things, that these were not the tablets, say supposing, my lord. Because there are no batch number, no
Nothing.
No
identification.
My lord, will it, my lord, basically have a bearing on the case so far as the seized material is concerned, my lord? Because, my lord, it is in the evidence that the same tablets are available in a medical store. Say supposing, my lord, if it is to be replayed, so whether, my lord, the composition of the things would change.
Composition of what?
Of those tablets. The composition. What I am trying to...
It is possible you got a lot of stuff from them. But there may have been no spasmopoxyone in it at all. And when you produce in court, you produce spasmopoxyone. They don't say that they were not on the scooty.
My lord.
Or he.
My lord.
He was the driver.
My lord.
The bag was found from the actual physical possession of the pillion rider.
My lord.
May also have been in his constructive possession. Accepted.
My lord.
Bag was opened. Certain material was found. Chance recovery. Seniors were informed. Anti-narcotic team arrives. Seizure made in their presence.
My lord.
They record this is seized. Does that contain the signature of the accused? The seizure list. Will the seizure list contain the signature of the accused? If the seizure list contains the signature of the accused, then you can say that yes, he has admitted the spasmopoxyone was taken from him. Whether it is that or whether it is something else, that is not material. The seizure list does not bear his signature. You write down so much was recovered. It is possible in such a scenario that none of the material which was recovered was a contraband, but later a contraband, whether by mistake or by design, was planted. So for us to accept, when generally the scheme of the act is so against the accused, for us to accept that this was the material which was taken out of the blue bag, there must be some identification, either tick mark at the end of the strips or the seizure list saying batch number so and so or expiry date so and so.
The identification mark is not there, admitted, my lord. There is no question of me, my lord, trying to say.
Now, how do you link the one that was produced in court to the one that was recovered from them? Just that one question. How do you link it to the one that was taken from them?
My lord, the two things I would say, my lord. First of all, the seizure, so far as the seizure of the plasmoproximon tablet is concerned, my lord, that has not been denied. Now they are raising dispute, but then
Please.
My lord, not denied in the sense, my lord, so far as the seizure list is concerned,
are they given a seizure list?
Definitely there has been given, my lord. That has to be given, my lord, before trial, my lord.
That is at the 207 stage.
My lord.
Prior to that, at the time of seizure,
My lord.
is there signature obtained like on a panchnama?
My lord, it should be, my lord. Normally it is
Just check that.
I have to verify it in the records, my lord.
Just check that. If that is done, then it does not lie in their mouth to say, because very well.
My lord, I'll have to go through.
Some spasmopoxyone was given the lower court records, madam.
See the exits. Caesar list will be.
Both of you go through the law court records, come back tomorrow.
No. Exhibit 2 should be.
Page 5. Caesar list, page 4 and 5. And original is at page 6. Your Lordship will kindly see on the margin at page 6, madam. Their signatures are there.
They have signed, my lord. They have signed it, madam.
This is before charge, madam. But even then they have to link the sample, control sample drawn, madam, with this, madam.
But their signature
We'll come back tomorrow.
but their signature appears in the Panchnama
No, my lord,
on 20, dated 22, my lord, same day.
my lord, it may sound preposterous to your lordships, my lord. Subject to my friends, can we have it on Monday, my lord?
No. Finish it now.
Yes, ma'am.
Now. Finish it now.
Today, sir?
Yes?
Today, sir. Yes.
That's all. We don't need them anymore.
That's all.
You say whatever you have to say.
My lord, possibly your lordship, my lord, what your lordship wanted is the linking of that control sample to, even if I had signed in the Caesar list, my lord, that will not mean that it was drawn by, that control sample was in absence of it being taken before the magistrate. That is my submission, my lord.
Anything else?
And my lord again, my lord. Good. My friend has been very helpful, my lord. The Caesar list contains of 2 pages, while page 6 has the signature. The second page, page 7, it doesn't carry the signature. This is important. Page 7, man. Your lordship will see, page 6 it starts, Caesar list. On the left hand margin, the signatures are, madam, accused persons are there, left side, madam. But in the next page, page 7.
All right. Now, page 6, 2 things about page 6. Page 6, see description of seized articles.
Yes.
1, 2 bundle of Strasbourg proxy 1.
Yes.
Then 7 bundle of Strasbourg proxy 1.
Yes.
Then 2 bundles of Strasbourg proxy 1.
Yes.
And page 7 also has all that.
Yes, madam.
Including one lot of 18 strips. 18 strips.
Madam.
These are bundles, they have 18 strips.
Yes.
Then one blue color bag and something. That is number 1. Number 2 is that you were given this copy of the Caesar list in course of 207.
Yes.
You do not object, you do not say page 2 is not, has been fabricated.
No, it was not 207, this is a charge film. Well, during the framing of charge, nothing was given, madam.
Has to be given. Everything has to be made over to you.
Well, charge sheets were not
Section
produced.
207 of the Criminal Procedure Code.
Well, charge sheet was not produced.
Comes in
Charge sheet
section
is not
207 of the
executed.
Criminal Procedure Code.
My lord.
Then you should have objected then.
Charge control. 20 supply to the accused of copy of police report and other documents. In any case where the proceeding has been instituted on a police report, the magistrate shall without delay furnish to the accused free of cost a copy of each of the following. Now, yes, madam. I understand. But the police papers, your lordship is
207, 208 is the corresponding provision.
police papers before framing up the charge. Madam, the charge, madam, I have been, this is another argument, madam, it was left out, madam. I have been sought to be accused as a transporter, madam, as is evident from the prosecution side, as also from the court, madam. Even if I am held as under 22C, madam. Now 22C incorporates the word transporter. Very correct, madam. But there is a specific provision for transporters or abettors, madam, which is section 8.
Make whatever argument you had made before, don't expand on it, deal with whatever he has said. You had concluded your arguments, we don't give you a chance to make out a new case in the rejoinder.
No, my lord,
you only have to deal with this.
But, my lord, you're also asking me on charge, my lord. The police papers definitely, my lord, I do not know, but I think police papers are given before framing of charge.
Because all that we find is that you are fooling with us. You think we are a joke and you are fooling with us. That's the substance of your argument.
My lord. My lord, it is not so, my lord. My lord, police paper is given, my lord. I didn't understand your lordship when your lordship asked me, but police were given, so I admit it. I have not gone through the records also.
Is that a serious argument anyone will make?
No, my lord. My lord, my
first page contains my signature, second page does not contain my signature. If it was so, you ought to have done it with the trial court.
Very correct, madam. Very correct, madam. So I left it at that, madam.
Yes.
Only the second limb in the charge, madam. Madam, I have been, madam, I have been convicted and charge was framed under section 22, madam. But
section 22.
Section 22, madam. 22C.
That is the usual provision for everyone.
No, madam, your lordship will kindly come to. If I was at all a transporter, my lord, although, my lord, no link has been established by the prosecution between me and the other accused.
The contravention involves commercial quantity. That's 22C. Whoever in contravention possesses.
Your lordship will find the word transport.
Possesses also.
Possesses.
You possessed.
I didn't possess, madam. The co-accused possessed.
You possessed. You were in constructive possession. That is what has been found against you. You possessed. The fact that it is not physically found in you does not mean that you do not possess. You constructively possessed. But that's the finding.
But that question was not posed to me, my lord. But other things, my lord, which I am at, my lord, section 8, your lordship will kindly come to once more.
8,
my lord. 8, again there is A, B and C, my lord. Your lordship will see. C, produce, manufacture, possess, sell, purchase, transport.
All of them are same.
Transport.
So whether you do it as a possessor or as a transporter is the same. There is no difference.
Well, it has been specifically made this section, that is why I just pointed it out to your lordship, my lord. Because to lead a, my lord, defense, my lord, such should have been, my lord, frame, my lord. That is my humble submission.
A case could have been made out on your behalf before the trial court.
My lord.
That not having been made out, you are today precluded from.
My lord, I have to lay hands on whatever material. Your lordship will understand, my lord.
We are not.
Very young boys, my lord.
That's neither here nor there. That's neither here nor there. The evidence is that drugs were found from their possession. Whether they are young or they are old will go into consideration of the sentence.
My lord.
Sentence is not so harsh for us to tinker with it. 10 years.
10 years is a lot, my lord, in a man's life, my lord.
Look at the quantum of drugs.
Now this quantum, again, my lordship, I had submitted, my lord. This doesn't match the IO.
It is commercial quantity.
But, my lord, again,
commercial quantity of contraband.
My lord, this page 1440, it is 2350. Even if it is commercial quantity, my lord.
4272 capsules.
But 4272 as per Caesar list.
Yes.
But as per IO, it is 23. I have made it.
What is commercial quantity in this case? What would be commercial quantity?
Section 32. It's the page, page 32 of the paper book. Malayalam also can come to page
13 of the paper book.
32. 5 IO. Huh? What is it?
13.
Commercial quantity ক'ত লিখা আছিল commercial quantity কিমান হল commercial quantity এখন চাৰ্টখন আছে ন schedule
The quantity has been determined by the trial court, man. Lordship will come to page 103, man.
103.
My lord. My lord, paragraph 24.7.
7. The weight of 4272 capsules from the above computed conversion to the unit comes to 2 and kilogram once to view the
My lord, 2.17872 kg. My lord.
So what would be commercial quantity?
My lord, commercial quantity, it is much more than quantity. Lordship, what's the chart? What's the chart of these things? Just take out. The commercial quantity.
My lord, this will be available, my lord, from the schedule, my lord. Compound to কি আছিলে?
500 grams. My lord, 500 grams.
500 grams.
500 grams, my lord, and serial 33.
500 gram.
Yes.
Serial 33 of the table of notification. And this is more than 2 kg.
My lord.
The appeal has been carried by one of the two convicts against a judgment of June 16, 2022, June 15, 2022, and the consequential sentence of June 16, 2022 in a case originating in this capital city. Full stop. The principal ground, paragraph, as of now, comma, there may not be any appeal preferred by the other convict who suffered the same sentence of 10 years reduced imprisonment with a fine of rupees 1 lakh, full stop, in default of the payment of fine, they are to undergo 2 further months of simple imprisonment, full stop. The time of detention was taken into account and the remainder of the period of detention indicated in the sentence. Full stop. The sentence followed the appellant's conviction under section 22C of the Narcotic Drugs and Psychotropic Substances Act 1985 for, inter alia, possessing, now for, not inter alia, for possessing or transporting commercial quantity of psychotropic substance full stop. About 4272 capsules of spasmoproxivon bearing a net weight in excess of rupees 2.1 kg dash where the commercial quantity is reckoned at 500 gram dash were recovered from the joint possession of the two persons riding a scooty and the trial court found that even though the blue bag containing the contraband was in the physical possession of the pillion rider and not the present appellant, the present appellant, the appellant was deemed to have been in constructive possession thereof. Full stop. Paragraph. The incident occurred on February 22, 2013. Full stop. The case made out by the prosecution was that in course of additional checking during the election period, the police party led by PW1 made a chance recovery of the contraband from the scooty and or from the joint possession of the appellant and the pillion rider. Full stop. The further case made out in the prosecution, by the prosecution and in the oral evidence at the trial was that PW1 immediately informed his superiors, whereupon members from the anti-narcotics team, task force, were sent to the spot, whereupon the contraband seized were recorded, a seizure list prepared, and the signatures of both the then accused persons obtained thereon. Full stop. Paragraph. 3 principal grounds have been taken in this appeal. full stop. For a start, comma, great emphasis has been laid on the fact that the blue bag which allegedly contained the contraband was apparently recovered from the physical possession of the pillion rider and not from the appellant. Full stop. The second limb of the submission pertains to the presumption that arises under section 35 of the Act. Full stop. The third contention raised is that the material seized could not be linked to the material that was sent for forensic examination or the contraband which was ultimately produced in court at the time of trial. Full stop. Some murmurs have also been made on section 52A of the Act and the inadequacies in the manner of dealing with the contraband, semicolon, however, comma, the goods seized in this case, the contraband seized in this case had not been destroyed but had been preserved and produced at the time of trial, where PW1 identified the material exhibits and also proved his signature. Full stop. Paragraph. The main thrust of the argument is on section 35 of the Act and the judgments reported at 2000(2) SCC 513, 2018 17 SCC 627 and 2020 16 SCC 709 have been placed to indicate the scope and purport of the provision and the perceived failure on the part of the trial court to apply the law appropriately in the present case. Full stop. Section 35 of the Act provides as follows. Set out. Full stop. It is evident on a plain reading of the provision that both the explanation in subsection 1 and the substantive provision in subsection 2 are in aid of the primary rule enunciated in subsection 1. In other words, a presumption arises as to the culpability of an accused and it is for the accused to prove that he was not culpable in respect of the act charged with by the prosecution. Full stop. In a sense, subsection 2 is merely clarificatory, and subsection 1 may have stood in its own steam without subsection 2 being there. Full stop. Subsection 2 reiterates a fundamental principle in criminal jurisprudence that the test applied in a criminal matter is one of beyond reasonable doubt and not one of preponderance of probabilities. Full stop. Paragraph. In certain cases, whether it is in the assessment of a fact, of a special fact, or in the manner or in the matter of rebuttal of a presumption, the general rule of beyond reasonable doubt may not apply. Full stop. In the present case, subsection 2 above emphasizes that the degree of proof that the fact that has to be established by an accused in an NDPS case is beyond reasonable doubt for the rebuttal to be accepted. Full stop. Subsection 2 of section 35 of the Act has no manner of application beyond the rule enunciated in subsection 1 of the provision. Full stop. Paragraph. In the first case cited by the petitioner of Abdul Rashid Ibrahim Mansoori, the accused was an auto rickshaw driver who was intercepted and 4 gunny bags containing cannabis was found in the auto rickshaw. Full stop. It was in such circumstances that the trial court acquitted the accused, but he was convicted by the High Court which referred to Section 35 of the Act. Full stop. Paragraph. It is not paragraph, even that. It is in such context that the Supreme Court analyzed Section 35 of the Act to observe as follows at paragraphs 21 and 22 of the report, set out. Paragraph. In the case of Mohanlal, $4 kg of opium was recovered from the accused as the contraband was found in a bag carried by him. Full stop. While the Supreme Court ultimately found that the investigation conducted in the particular case was vitiated, the following observation on inter alia Section 35 of the Act is found at paragraph 12 of the report. Quote. Paragraph. In the final case of Hanif Khan, the allegation was regard to the illegal sale purchase between the appellant before the Supreme Court and an acquitted co-accused. No appeal had been preferred by the state against the acquittal. Full stop. It was in such context, when the principal person had been acquitted, the Supreme Court doubted the conviction of the appellant before it. Full stop. Paragraph 8 of the report quotes a previous Supreme Court judgment as to the scope of Section 35 of the Act, set out. Paragraph. There is no doubt in the present case, as appears from the oral evidence at the trial and the meticulous discussion thereon in the impugned judgment of conviction, that a scooty was apprehended, a bag was found in such scooty which may have been in the physical possession of the pillion rider, and inter alia commercial quantity of contraband found in the bag, full stop. Since this was a case of a chance recovery, the trial court dwelt at length on the applicability of Section 50 of the Act and the rigors that such provision carries in case of a chance recovery, full stop. Ultimately, upon relying on a judgment reported at 1999 6 SCC 172 bracket State of Punjab versus Baldev Singh, the trial court concluded that Section 50 of the Act would come into play only in the case of a search of a person as distinguished from search of any premises, and that in case of a chance recovery, such provision would not apply. Full stop. Paragraph. The trial court also considered at length whether the accused persons were in conscious possession and transporting the contraband, full stop. On such aspect, the trial court recorded the articles that were seized, noticed that the seized articles had been duly deposited and that they had been produced at the time of the trial. Full stop. According to the appellant, there was no link between the goods that were seized and the goods that were ultimately produced at the trial. A further point is taken that though the first page of the seizure list has been signed by the appellant herein, the second page does not bear the signature of either the appellant herein or the other convict. Full stop. Paragraph. It is evident from the seizure list that several bundles of spasmoproxivon capsules were recovered from the bag in question. there cannot be any denial of such fact, comma, particularly at this stage, comma, when the appellant did not question either the seizure list or the appellant's signature thereon, full stop. It is true that the second page of the seizure list does not bear the signature of the appellant or the other convict, semicolon. But if the appellant were to seriously question the veracity of the second page of the seizure list, comma, that should have been done in course of the trial, since the appellant, comma, no doubt, comma, had been forwarded a copy of the seizure list in accordance with the requirements of inter alia sections 207, 208 of the Code of Criminal Procedure 1973. Full stop. The further point made on behalf of the appellant is that at the time of seizure, no recording was made of the batch number of the capsules or the expiry date for it to be later established that the articles produced at the trial were the same articles that had been seized at the time of that had been seized from the possession of the accused. Full stop. Ideally, comma, the officer seizing the contraband, comma, particularly as they were manufactured medicinal products, as in this case, comma, should have indicated the particulars just as a prescription would, full stop. Ideally, comma, the batch number of the strips or the expiry dates thereof or both ought to have been recorded, full stop. However, comma, what is of relevance is whether the failure to indicate such particulars has resulted in any miscarriage of justice or has resulted in any miscarriage of justice. Full stop. Paragraph. It is plain from the first page of the seizure list that several bundles of the contraband had been recovered from the blue bag, comma, whether or not such bag was in the actual physical possession of the appellant. Full stop. Even without referring to the second page of the seizure list, comma, the quantum of the contraband indicated in the first page thereof would cover the quantum required to would make up commercial quantity of contraband. Full stop. Since the appellant did not question either the veracity of the seizure list or the contents thereof, comma, even on the first page thereof, comma, it matters little whether the batch number or the expiry date of the seized material had been recorded. Full stop. The appellant herein is deemed to have accepted that the goods as recorded in the first page of the seizure list had been recovered from the scooty or the constructive possession of the appellant or, at least the physical possession of the pillion rider. Full stop. So much cannot be questioned. Full stop. Since the quantum of the material appears to have been of commercial quantity, since the quantum of the material seized was commercial, since the quantum of the material seized made the seizure one of commercial quantity, whether or not the same material was produced at the trial is of no consequence at all. Full stop. Paragraph. As to whether the goods were found in the possession of the appellant or the goods had to be regarded to have been found solely from the possession of the pillion rider, the trial court has examined the matter at great length. Full stop. Referring to the concept of constructive possession in such a scenario, particularly when the driver of a vehicle would scarcely be in a position to physically carry the contraband on his person, the trial court concluded that in the absence of the appellant herein demonstrating that he had no connection with the seized contraband, he was deemed to be in constructive possession thereof. Full stop. It is for such purpose that Section 35 of the Act has been stressed upon by the appellant in course of the present proceedings. Full stop. Paragraph. For such purpose, the appellant suggests that if possession of the contraband by an accused is not established beyond reasonable doubt, or if the goods are not identified beyond reasonable doubt, then the burden in terms of Section 35 of the Act is not required to be discharged by the accused. Full stop. Further, it is the case of the appellant that in his response to the first question put to him in course of his examination under Section 313 of the Code, he disowned the bag and indicated that he had nothing to do with the same. Full stop. The appellant submits that in the light of such statement and the fact that and the admitted position that the blue bag which contained the contraband was recovered from the physical possession of the pillion rider, the appellant could not have been prosecuted or convicted. Full stop. Paragraph. In reading a provision or applying the same, comma, there is a bandwidth of reasonableness that has to be maintained. Full stop. It is possible that in a bigger vehicle, there are several persons and a bag containing the contraband, which is not actually in the physical possession of any of the passengers. Full stop. In such a scenario, comma, unless there is a suitable explanation as one required under section 35 of the Act, comma, the passengers would be deemed to be in constructive possession of the bag and the contraband contained therein. Full stop. In a less spacious vehicle, as a scooty, where the driver has both hands on the steering and the lever, and the only spaces are, comma, probably, comma, a little footboard to the front, comma, a little carrier behind, and the person of any pillion rider, comma, it is not surprising that any goods carried in such a scooty would not be actually in the lap of the driver or in the driver's actual physical possession. Full stop. But that would not, comma, by itself, comma, imply that the driver was not in possession of the contraband, since the said act has a built-in principle of constructive possession, as has been referred to in copious detail by the trial court. Full stop. Paragraph. It may have been possible for the appellant herein to demonstrate that the appellant had no nexus with the pillion rider, or that the pillion rider was taking, or that the pillion rider had merely requested the appellant to give him a ride or the like. Full stop. However, comma, no attempt was made by the appellant in course of the trial to either establish the circumstances in which the pillion rider came on board, or the lack of the appellant's connection with the pillion rider or the blue bag that was found in the physical possession of such pillion rider. Full stop. Paragraph. The trial court has referred to the circumstances of the seizure, comma, the quantity of the contraband seized and arrived at a just conclusion that the petitioner could not have, the appellant herein could not have been said not to possess a mental culpable state in the recovery of contraband from the vehicle or another person that the appellant was driving. Full stop. In the order on sentencing, appropriate considerations have been taken into account before directing the appellant to suffer the sentence of 10 years rigorous imprisonment and a fine of rupees 1 lakh, full stop, paragraph, based on the material that the prosecution put on display and the appreciation thereof by the trial court, neither the judgment of conviction nor the consequent sentence call for any interference, full stop. Criminal appeal number so-and-so is dismissed. Paragraph, let a copy of this judgment and order be immediately made available to the appellant free of cost. Yes.
Item number 6.
Yes, put this in.
The paper book is yet to be prepared.
Here?
Paper book is yet to be prepared.
Oh.
I have not received. Yeah. May I please your lordship, actually I was out of station, that's why I could not.
Paper book is ready?
No, not yet, my lord. I'm seeking 3 weeks time, my lord.
Since the paper books are not ready, the time to prepare the paper books is extended by 3 weeks from date.
Order.
The appeal will appear 5 weeks hence.
Hello.
After a long time of proper disposal.
On the main list, item number 1.
I'm for the respondent here, my lord. Lordship, here the trial court records, if they are called, my lord.
What is this matter?
This is, my lord, delay was condoned by the trial court.
Yeah.
My lord, my learned senior is here challenging that order condoning the delay. This is a very, very old suit, my lord. In fact, the suit was filed in the year 1987. And thereafter, my lord, in the year 2014.
This is civil division.
Civil division, my lord.
Very good. Yes.
My lord,
How many days delay condoned?
now 3,039 days delay.
Well,
Trial court has
submission
entertained
has been
the
shown.
application for condonation. So I'm agree with that, my lord.
And what was the ground?
The ground, the applications seeking for condonation, no ground was disclosed. They say that the plaintiff expired in 2011. And only they came through in 2016.
No.
So those are bad, my lord.
Will not do.
My lord, what has happened here is.
Will not do.
But my lord, if I lordship, I'll just explain once. Well, if
I'm not dismissing it today.
records
I'm
are
not
called once,
dismissing it today. We'll keep it sometime next week.
I will try, my lord. on that.
Try. Will not do.
If records are called, my lord,
No, not at all. Not a fool.
lordship.
Let it be dismissed from merits by then. Good enough. All right? We'll appear next Wednesday.
Obliged. Obliged.